Today. My name is Ken Levinson. I'm the Executive Director of WITA. Thrilled to have so many of you here today for a topic that I've been talking about with almost each of these panelists and discussants for almost the past year. It's something that we actually previewed quietly at WITA when we circulated a op-ed written by former Senator Bob Dole, talking about, I want to say it was about 1999. He wasn't in the Senate anymore, but he was talking about U.S. sovereignty and the WTO and how we needed to have a three strikes and you're out provision in the bill. And we stuck it in some WITA communications. We sort of, after Bob Lighthizer was nominated to be USTR, we kind of buried it in one of our communications on our Friday Focus emails because it was something that was about this very topic. And it's something that's been percolating for that long. People like Terry Stewart were actually whispering in my ear about this topic with Bob Lighthizer, Alan Wolf, Gil Kaplan, a lot of the people who are in this administration and in positions today with Alan at the WTO about this topic while we were contemplating the legislation to join the WTO. This has been something that was foreseen and anticipated, I think. And as Terry, we've circulated some of the papers Terry's written, there's many cases that he's been able to cite over many years because it's been something that's been building. Bruce Hirsh, who worked on these issues when he was at USTR more than a decade ago, Jennifer, and Warren. Warren also worked with Bruce on those very same papers more than a decade ago. Jennifer, who was at the WTO. So we're really delighted to have this panel here. We have a couple great events coming up at WITA. We hope to have all of you at next week. We've invited back four former congressional trade counsels. Grant Aldonis, Brian Pomper, V.G. Rangaswamy, and Nina Shania worked on Senate Finance, House Ways and Means, to talk about the role of Congress in trade policy. And then we just announced yesterday that we're going to be doing the first, we didn't say it's a series, but it actually will be. We're going to be doing 2 or 3 events on China, U.S.-China trade over the next 5 or 6 weeks. And the one that we announced yesterday is called China 2025 and Beyond. And it's sort of a background. What is happening in China? What is going on? What is happening geopolitically with China? What is happening economically? Why are there trade tensions? Why are the things that China's doing causing such pressure on the global trading system? We have some great speakers for that. That's on May 3rd. I'm going to monitor my Twitter feed during the event today in case anything comes up, but we might have to do an event on TPP, which I hadn't anticipated. We'll also, of course, we had promised 2 more events on NAFTA. As those negotiations progress, we will hopefully we're going to be getting into additional events and discussions of the NAFTA issue. So with that, I'm going to turn it over to our terrific panel. Warren Moriarty, an old friend, has agreed to moderate the discussion. I'm really grateful to all of them for being here. With that, turn it over to Warren. I think it's on. Speaking to the mic, thank you.
Welcome, and it's great to see such a big audience for such an obscure legal topic. Most lawyers and legal scholars would agree that the GATT and WTO dispute settlement mechanisms were a huge breakthrough in international law. Despite their celebrity, a lot of international treaties with very important goals and aspirations, in the end, are just pieces of paper because they lack an enforcement mechanism. And as a result, the WTO is virtually unique in having a dispute settlement mechanism that ensures compliance with the rules, a deep body of jurisprudence interpreting those rules, and clear, if long and winding pathways to penalties for non-compliance. Over the past 2 decades, the panels and Appellate Body have developed an extensive body of decisions that have provided a lot of work for scholars and lawyers. The U.S. experience, though, has been mixed. We've won just about every offensive case that we've brought, including important decisions on GATT Article 3, on sanitary and phytosanitary, technical barriers to trade, subsidies, and IPR. But we've also lost just about every foreign challenge to our trade remedy laws, anti-dumping, countervailing duties, Section 201. And as Jennifer and I can attest, it's a long walk down the hallway from the 2nd floor of the Winder building to tell your boss that you've lost another WTO case. Right now, there's a major impasse in Geneva over the Trump administration's refusal to agree to new appointments to the Appellate Body. Many of these concerns that the administration is raising are not new. They go back at least a decade. Both the Bush and the Obama administrations raised concerns about Appellate Body overreaching. And we've been warning our friends in Geneva for a long time that unless the Appellate Body showed more discipline, they were putting political support for the dispute settlement mechanism in the United States at risk. But the Trump administration has brought a new level of intensity to these concerns, and as a result, it's, I think, unclear to most people, including me, whether this is just a temporary diplomatic fuss or an existential crisis for the WTO. Today, we're really privileged to have a stellar panel to share their insights into the WTO dispute settlement system. Jennifer Hillman served as an Appellate Body member and currently teaches international trade law at Georgetown, following in the footsteps of John Jackson. Before being appointed to the Appellate Body, Jennifer served as a commissioner at the U.S. International Trade Commission, as USTR's general counsel and chief trade negotiator during the Clinton administration. Stewart is a distinguished member of the trade bar and the managing partner of Stewart & Stewart. He's been involved in virtually every major U.S. trade proceeding of the last 30 years. I'm not sure how Terry finds the spare time, but he's also written extensively on the WTO, including a negotiating history of the Uruguay round that's been widely cited and that I can attest has been extraordinarily useful to some of us at USTR. And his dad, Eugene L. Stewart, helped pioneer international trade laws and legal specialty in the 1950s and 60s, for which all of us in the trade bar are eternally grateful. And finally, Bruce Hirsh is the founder of Tailwind, which provides strategic advice on international trade and regulatory issues. Bruce served as Assistant U.S. Trade Representative for Japan, Korea, and APEC, as our Deputy Assistant USTR for WTO and Multilateral Affairs, Chief Counsel for Dispute Settlement during my time there, and then as Legal Advisor to the U.S. Mission to the WTO. He was also, from 2011 to 2014, Trade Counsel to the Senate Committee on Finance, and his work on the Baucus-Camp Trade Promotion Authority legislation helped lay the groundwork for the extension of TPA in 2015. And with that, for the panel, are the Trump administration's concerns about the WTO dispute settlement mechanism legitimate, and particularly its attacks on the WTO as a threat to U.S. sovereignty?
But by answering this, I want to start, I think, with what is a little bit of context that I do think is important in thinking about it. Because to me, the U.S. attacks, to some degree, stem from whether the U.S. got what it thought it was getting when we went into the Uruguay round and the WTO system. And three issues, I think, that I would point out where I think the discrepancies lie that have some significance. First is, if you read back to what did the United States say when we were entering into the Uruguay round agreements, it was a lot about how important a binding dispute settlement mechanism was going to be because we wanted to enforce our market access rights. We were putting in new provisions in the WTO agreement, and we wanted to make sure there was real teeth behind those rules. What we didn't think about is sort of what you talked about, which is what would happen when we were on the defensive side. So if you think about it and you read it, it looks like we were going to be entirely on the offense. And what has happened is that the United States has brought 117 complaints, but they've been the defendant in 136. And that was certainly not anticipated. The expectation was that we were the most open market with the most transparent set of rules, and therefore unlikely that we would be on the losing end. And to the extent that we thought about being on the losing end, or at least on the defensive end, I think we put a lot of faith in one phrase out of one of the articles of the dispute settlement system that said that one of the points of the dispute settlement system was not to create rights or obligations that were not in the text. The United States relied on that, I think, very heavily to think that we were not going to be on the losing end. And secondly, we relied very heavily on a very specific standard of review that exists only in the context of anti-dumping. So again, I think part of it is we've ended up sort of being on the defensive more than we expected. The second thing I think that didn't turn out as the United States had envisioned it, and I think it is really very significant, is the appellate process itself. And again, the United States was one of the major proponents to have an appellate review mechanism because we realized that when we were moving from a GATT system that was not binding, in the old GATT days, if you didn't want a panel to hear a case, you simply blocked the establishment of a panel. If at the end of the panel process you lost, you could simply block the adoption of the panel report. So we didn't really have a lot of worries in the old GATT days about needing an appeals mechanism because we used the blocking, in essence, to stop anything we didn't like. Along comes a now binding dispute settlement mechanism, and the United States and others realized that, oh, we need an appellate mechanism to deal with sort of rogue panels that may have gone off the rails at some point. We needed an appeals mechanism. But the understanding of the United States, and I think really most of the members, is that appeals would be rare and that they would be limited to a few very precise legal issues. What's turned out? On average, 68% of all cases are subject to appeal, and if you look over the last couple of years, it's over 90% of the cases have been appealed. And secondly, if you look at what's being appealed, again, it started out with 2 or 3 claims on appeal. Today, an average of 15 claims made on appeal, and many of them go well beyond the idea of just a legal interpretation. Did the panel get a legal interpretation right or wrong? In US parlance, this is Article 11 of the DSU, where the legal claim is that the panel did not make an objective assessment of the facts. So now, all of a sudden, the appellate body has been dragged in virtually every single appeal to a re-examination of the facts of the case. So again, the whole appellate process is just way bigger, more, and beyond anything that was ever imagined. And the third thing I would say is just the number, length, and breadth of all of the cases is way beyond what anybody would have imagined. Again, in the early days, again, you had a case that challenged a single measure with on average 3 or 4 claims being alleged. Today, disputes on average 28 government measures are included in your average complaint with more than 180 claims. So, you know, the numbers are just getting out of control. You add on top of that early on there was the notion that governments didn't necessarily have to be represented by their government officials. They could hire private lawyers, maybe even in this room, to be litigating those cases. Guess what? As a result, again, the briefs become longer, the claims become more. Today, on average, you know, again, you're just seeing party submissions running to hundreds of pages, many of the cases having exhibits in the thousands of pages. You've also seen all of these third parties come into it. My only point is the entire process has become way more complex than anybody imagined. And what this does speak to is the United States' claim. And here I would say the United States is not alone. That the process was supposed to deliver swift justice. I mean, you were supposed to end these cases in 18 months, including the appeals times. And we're not anywhere close to that these days, I think, because of all of these changes. So the United States' expectations for sort of swift decision-making, again, tied to the text, has not panned out. And I think that's the sort of context in which we need to think about whether there really is this crisis. And for my money, I'm very, very worried that the United States' blockage of the appellate body has the potential to bring down the dispute settlement system, and with it, a rules-based WTO. So I don't think we can understate how significant this is.
Harry?
Good morning. I typically am on these panels so that I can present the doom and gloom scenarios. So I'll try to be successful in that. If you go back to when the Uruguay round was being negotiated and implemented into U.S. laws, as Warren said, there were tensions. The U.S. was very concerned about, in particular, our good friends in Europe, and particularly whether or not they were complying with agricultural obligations that the United States felt that they should be. same time, there was significant concern in the Congress about whether or not in agreeing to binding dispute settlement, we would be finding ourselves forced to accept obligations that the United States was not aware it was accepting. And if you think about most governments, why any government would want to be put in a system where they're forced to accept obligations that they haven't agreed to, it seems like a totally reasonable concern for democracy to have and for the Congress to have. As a result, if you look at the DSU, there were not one but two articles that specifically provide that panels in the appellate body can't create rights or obligations, while it is the obligation of the panels or the appellate body to interpret the agreements that are before them. There also were safeguards put into the system that were designed to be the checks and balances that you would have in a nation state. One of the sad results of the first 23 years has been that the checks and balances have never worked. They've never been invoked. And in a consensus-based system, it is hard to see how they ever will be invoked. So you basically have an appellate body that can make the decisions that they make with no ability to cross-check them other than through negotiations. When the WTO was created, because binding dispute settlement was a novel idea, a lot of countries wanted to have a very quick review within the first couple of years to be sure they hadn't gotten into something that trapped them into something that was unworkable. So we were supposed to have had a review of the dispute settlement understanding by 1998. And so at that time I was a young man. And here we are in 2018, and we are still a long way from having a resolution. So the ability to negotiate solutions to the problems are very real. So we have, as Warren said, we've been building since before 2002. I mean, Congress, after all, in 2002, and the Trade Promotion Authority had requirements for the administration to deal with the perception that there was significant overreach. And it's not that we lose every case. Everybody loses every case. This is the ultimate plaintiff's court. Over 90% of cases brought will be won. And you can say, well, this obviously is an indication that countries are being very selective and only going after things. I can tell you that that is far from true. And I've had friends in Geneva who have told me that they had a case that they brought that they were very concerned that they should lose. And so the way to get around that was to try to gin up enough other country support to make it look like this was the threat to the system that everybody was concerned about. So the question, will the WTO self-destruct? It certainly seems like it is moving in that direction. Our trading partners have ignored close to 20 years of signaling from the United States, a minor player in the WTO, that there were serious problems. We are now past the tipping point in this administration, and in my view, you do not see a restoration of normalcy, i.e. the selection of new appellate body members, unless and until the core issues the United States has laid out get addressed